Good morning, Your Honor. Jennifer O'Brien, the defendant, Asmar Hines. With me today is Amanda Hebert. She's a 303 certified law student in my office who's going to sit in. As you know, this case specifically addresses the statute 265, Section 18B. Specifically, we're looking at whether there's sufficient evidence to prove the defendant possessed a firearm while in the commission of a felony. First of all, does that statute apply? And secondly, if it does apply, was there enough evidence against this particular defendant to convict him? And as you are aware, the underlying felony which enhanced the penalty in the gun charge is possession with intent to distribute. I think this court obviously is aware of the Bailey decision and the fact that the federal Congress, rather, changed their statute after Bailey, and so did the Commonwealth of Massachusetts. I think it's interesting to look at the differences, and in looking at the differences, it's clear that Massachusetts intended this statute to be more limited in scope.
I have two questions. One, I assume this is true, but I didn't see, maybe I missed it, that anybody actually said it. I assume that the defendant is a first-time offender.
Yes.
I don't think it said it in either brief, but...
yeah, I don't think it said
yeah,
either,
but it might have been helpful if that was put right up front, but I assume that. And the second thing, I'm not sure it's relevant, but did the defendant consent to the search of the safe? Does anybody argue that his consent didn't extend to the search of the safe?
I'm not arguing that. They did argue that at the suppression hearing. He said it was coerced and the police forced him to sign something. They did ask him if it was his jacket.
Not whether the consent was forced, but whether the consent, if it were a valid consent, assuming that it was, did it extend to the search of the safe?
That wasn't an issue at trial, and it's not an issue before you. So I think what the court has to focus on is whether or not this particular statute applies to passive crimes or crimes which is essentially an intent or a state of mind versus an active crime. If you look at the prior Massachusetts statute, it said whoever, while committing, uses a firearm. And then in the post-Bailey statute, they say while in the commission of or the attempted commission of has under his possession or control. And how do we know that this statute applies only to active crimes? I would argue that since they added the attempted language in there, that attempt by nature requires an overt act. So if the attempt requires an overt act, then surely the full commission of the crime would require an overt act. Possession with intent is not an active crime. If you look at the statute, it says any person who knowingly or intentionally possesses something with the intent to manufacture, distribute, or dispense it. The statute specifically says someone who intends to take an act or to take an action, not someone who takes an action. So
if somebody sets up a garrison around his stash, that's okay?
I'm sorry?
If somebody sets up a garrison around his stash to keep people away, that's okay?
Well, the crime is an intent. So I guess I know you can argue that the gun is there to embolden someone or to protect the stash. In this particular case, which is the second part of my argument, I argue that there's not sufficient evidence against this particular defendant.
But shouldn't that, why isn't that a jury question? And I guess my question is, how was the jury instructed on this issue?
They are instructed in accordance with the statute that if whoever if you find that the defendant has committed this felony, and there has to be a correlation. I don't know exactly the words used, but there has to be a nexus or correlation to show that it was.
Well, if we find that the instruction was not sufficient, wouldn't we just remand this for a new trial? The gun, the jury could find that the gun was possessed by your client in furtherance of his drug-selling operation.
They could find that, but even under the Lattimore standard, I don't think there was no evidence on that. This isn't a situation such as in Commonwealth versus Ella, where they had been, this person had been under surveillance, where they had evidence that he had brandished the weapon or.
No, but the gun was found in the safe with the proceeds of drug sales, presumably, or arguably.
Presumably, yes. Right. So I think that I would argue that the Commonwealth needs to prove more. They can't just prove that there was a gun at the scene, that he had drug money, and that he had drugs. They need something more to tie this into the crime.
Let's just assume, though, we adopted the sort of federal language, which I think would, in essence, require that the gun was possessed in furtherance of the felony, not just possessed, constructively possessed at the time of the felony, but somehow that there was a nexus. You're saying there's no evidence here that would support a nexus? Found in the same room with the drugs, with the gun with the drug money? I mean, no way that could be
I would argue that
submitted to jury?
no, that the motion for required findings should have been allowed, because this was a situation where they literally stumbled upon the defendant. They came in on an unrelated matter and found the drugs, found the safe, found the money and the gun.
Why should that make any difference? What if the gun was on the table with the drugs? Why should it make any difference that they stumbled upon it as opposed to went in with a warrant?
Because crimes in case law throughout both federal and in the Commonwealth of Massachusetts, there have been other things. This person has been watched. There's been controlled buys. They have evidence that the gun was within the arm's reach of the person.
Sure, that's certainly one way to prove it, for sure. But
absolutely. And with this, all they found was a gun in a safe. If one were to argue that the defendant possessed the gun to protect the drugs, to me this doesn't make sense. If you want to protect something, you would put it in a safe. So where the gun was in the safe instead of the drugs.
But what he did meets the literal words of the statute. He had it in his possession or under his control, didn't he?
He did have it in his possession and under his control, which is...
Well, what else do you need?
Well, I'm arguing that the statute doesn't apply. It doesn't apply to crimes where it involves a state of mind. And it applies to active crimes. The purpose of the statute is to be more harsh with crimes that involve a gun. If you're sitting home thinking about doing something that could never be inherently dangerous, the gun could never be involved. I don't think that Massachusetts, the legislature, intended to have this have this law applied to merely an intent crime.
But the crime here is intent to distribute. And while he's in his apartment, he has the intent to distribute. And the legislature knows full well that that's a crime. And they didn't exempt that when they wrote the statute.
They didn't exempt it, but they also didn't go further and add the additional language. It's been about 8 years since the statute was amended. If they wanted to specifically cover crimes that involved a passive state, like possession with intent to distribute, they would have added the language that the federal, the Congress did. During and in relation to and furtherance of any such crime possesses a firearm. The federal law is definitely more expansive than the Massachusetts law. And I think it's important that the attempted commission was added in there post-Bailey, because it's clear that the legislature wanted this statute to apply to active crimes. How could a gun ever be used when someone is thinking about something?
Well, the requirement that the gun be used is specifically taken out of the statute.
Yes, possessed in furtherance of that crime.
Well, possessed in the commission. I was reading in furtherance,
yes,
sort of consistent with the federal statute, but it says here possessed in the commission.
Well, I think it's important because what distinguishes the crime from a misdemeanor to a felony is that intent. So we have to look at the intent and when is the crime actually in commission. Obviously, it's in somebody's mind, so it's very difficult to ascertain when the crime would be in commission.
But there's more than just intent here. The drugs were actually in the house. They were in a closet near the guns.
Yes.
So there's more than just a dream taking place here. There's a possessory crime that's ongoing.
Absolutely. But it does not, the statute doesn't require a physical act or require you to do something. Obviously, the drugs aren't going to fall out of the sky. But for instance, if someone had a roommate and that roommate sold drugs and they took off in the middle of the night, the other roommate could literally come in and stumble upon the drugs, see everything, and say, I think I'm going to sell them myself. There's the crime.
I think you're trying to make too many metaphysical distinctions. The statute literally says if you commit in the commission or attempted commission, The commission of the crime here is the possession of the drugs with intent to distribute them. That's the commission of the crime. Okay, so next problem. Where's the gun? In his possession or control? Yes. Isn't that the end of the case?
No, Your Honor, just from comparing the Massachusetts statute and in the federal statute,
Forget the
I think
federal
the
statute.
Massachusetts
That's not our
applies.
statute. Why do we have to bother with the federal statute?
Because even if you completely disregard the federal statute, if you look at the Massachusetts statute, while in the commission of or the attempted commission, if attempt requires an overt act, then the full commission would require an overt act. Possession with intent to distribute, the elements of that particular statute do not require any overt act. You could literally just be come into possession with the way the roommate did, and once you intend to sell them, then there lies the crime. So my argument is that this particular statute would not require to an intent crime, would not require to a crime where there is no overt act. Obviously, a gun could never be used in your mind. The reason I think the statute is there is because a gun is inherently dangerous, and if it's kept nearby or used or possessed in furtherance of that crime, I don't want to say in furtherance because I know the statute doesn't say that, but to facilitate the crime, then it would be a crime.
Well,
But
the statute reads, while in the commission. In the commission must mean something.
yes.
For example, if someone is arrested breaking and entering into a home, felony, and a subsequent search is done of his apartment, 10 miles away, 2 cities away, and in the apartment, in a safe, is found a gun, isn't that what the real problem is here? How can that gun be possessed in the commission?
It's not. I think there's a big problem with the in the commission language.
It may be constructive possession, but how is it possessed in the commission? That's my problem.
Yeah, there has to be a nexus and correlation, and the way the statute is written, it is poorly written. Technically, you could have someone at home embezzling, doing something on the computer, a white-collar crime, and have a gun sitting next to them. They're committing a felony, and they have a gun in their possession or control. I know the case law...
Or a gun in the safe. Same situation here,
Or
except
in
the
a
crime
safe.
is he's doing some sort of computer fraud or something. And
The way the statute is written, he would be guilty, and he would get enhanced penalty. I think that the statute isn't clear enough. It's very vague, and the fact that it's vague should be construed in favor of the defendant and against the Commonwealth. The statute pretty much says any felony, but if you look at the particular language while in the commission, I think it's clear that committing a crime in this manner, since they went so far as to include the attempted commission, it does require a physical act. It requires an overt act. And a gun would never be dangerous in a crime that involves thinking. I know at some point you would have to get the drugs and package them and presumably take action throughout, but what raises this to the felony and makes the enhanced penalty statute apply is that intent. So it's not something we can brush off. So when is someone in the commission of a crime? When is that intent formed? And I don't think a gun would have any correlation to possession with intent.
now the firearm
Crime.
here, let's assume the firearm is totally properly licensed and all of that. It doesn't matter. Even if it's a properly possessed and licensed firearm, if it's possessed in the commission,
Exactly.
this crime is
Exactly.
completed.
And another thing about the whether or not there was sufficient evidence, again, I would argue that there wasn't. That there was no evidence that the gun was within arm's reach. Obviously, it was possessed. He had a key to the safe. But again, the gun was in the safe, so the gun presumably was the thing to be protected. The money was in there as well, but you would think that if you're going to try to protect something, the gun would not be inside the thing that you're trying to protect it with. Also, the key was inside a coat in the closet. So if somebody broke in, he's going to say, "Wait a minute, let me get my key, let me get my."
He had no
open
idea the
safe."
cops were coming.
He didn't.
Is there any evidence
But
that in prior sales he had taken the gun with him or taken the gun out of the safe?
No, they literally just stumbled upon him. There was somebody wanted in another crime, and they saw somebody go into his apartment that fit the description to that person, and it wasn't in fact that person, but they had no prior knowledge of this particular defendant whatsoever.
Ms. O'Brien, just one last comment. The recent case of Commonwealth against Ella,
Yes.
the appeals court case, it was helpfully brought to our attention, at least by the amicus and maybe by you as well. Doesn't that support the Commonwealth's position? In other words, he's dealing drugs, and there's a gun there.
Yes.
And the court says that's okay because you can you can permit the inference that the defendant kept his handgun there to protect himself and his business. There's no evidence.
There is, Your Honor. This case is very different than that. In that case, the police came in with a search warrant. There was an affidavit that there were a number of controlled buys. The defendant had 17 prior convictions on his record. There was statements in the affidavit from their informants
But that all
that the
goes to
defendant...
whether or not there's sufficient evidence to convict him of possession with intent to distribute.
I'm sorry, I didn't understand.
Well, what you're telling me is there was sufficient evidence there to commit.
Yes, there was. He actually took the gun out and brandished it during his other drug sales. And he also, should be noted, was charged with distribution as well. So I don't know if it's even clear whether or not that enhanced penalty applied to the possession with intent or the actual distribution charge. But they had been watching him, I think, for about 10 years. They had a lot on him.
Thank you, Ms. O'Brien. Mr. Townsend?
Thank you. May it please the Court, Thomas Townsend for the Commonwealth. Now, the statute, 265-18b, by its own terms, can apply to any felony. There is no distinction made between active employment of the gun or the intent to commit a crime.
Let me ask you a hypothetical. So say you have the same facts except the accused person has a key to a safe and they in their pocket, and they get on an airplane. They travel 1,000 miles away. They still have the control over the firearm, don't they? It's
Yes.
in a safe, but
Correct.
they have the key to
They would
the
have
safe.
constructive possession.
And so that would be considered to be while in the commission of a crime, and right?
My reading is not so expansive. I think
Where does it stop? I guess that's my question.
Well,
How do you figure that out?
I'm not of the opinion that if someone possesses something and commits some totally
Unrelated?
distinct crime, that I think there is a nexus implicit in the statute. I think there's a nexus implicit in the Eller's decision. And I think the words during the commission of the crime, you have to have the gun relate in some aspect to the crime. I think that was the intent of the legislature. And if you look at the legislative history, I think what they wanted to combat is the combination of felonies and guns, and more specifically, drugs and guns, the toxic confluence that comes from that combination. And certainly the federal statute, which we mirror to some extent, but ours isn't as restrictive as theirs. And clearly, in the legislative history of the federal statute, it was targeting guns associated with drugs. And after the Bailey case, which the Supreme Court read the word use as mean active employment in the crime, Congress and this Massachusetts legislature changed their statutes. They changed use to possess because they didn't want that high stringent standard that you have to actively employ a gun when committing the crime, but they still want some correlation between the two crimes.
Let's take the example. This case exactly. There's a gun in the safe, fully licensed to the individual, fully legally possessed in that sense. Gun in the safe, key in the coat in the closet, and the person is committing some form of computer fraud, some sort of crime on the computer that qualifies as a felony, whether it's downloading pornography or whatever it is. Is there a nexus? Would there be a nexus there?
Based on those facts, no. There has to be something to connect the possession of the gun, legal or illegal, to the crime being committed. I think that's implicit in the statute.
So should we read in furtherance of?
that
No,
language?
because the legislature specifically did not adopt that language. Congress is part of the legislative compromise after the Bailey decision. The federal statute used to have during and relating to language, kind of similar to what our statute has. The compromise in Congress was we would replace use with possess, make that a lower threshold, but at the same time increase the temporal and the nexus requirement to in furtherance of instead of during and relating to. So there was a switch off. Here what we have is has to be possessed not in furtherance of, but during the commission of. I think there is a nexus there, but it's not as stringent as the federal statute.
So is there sort of a natural affiliation between drugs and guns that supplies the nexus in this case?
I think there's more than that. I'm not saying every drug dealer who has a gun, legal or illegal, necessarily is subject to the enhancement statute. There has to be some indicia that that gun is related to the drug selling operation. That's why.
What is that in this case?
Well, that's why I went through all the federal factors, and even though the federal standard is much more stringent, I went through the factors because they provide useful guidance as the indicia that we can look at. And they go through several things about whether the gun was possessed legally or illegally, in the sense that an illegal drug is more likely to be related to an illegal drug. The illegal gun is more likely to be related to an illegal drug selling operation. Whether the gun was loaded or unloaded. A loaded gun presumably being more at the ready.
But I don't fault you for citing those when you say helpful guidance. It's never really helpful guidance when you've got clearly different statutory language. Well, because you just, I think, answered Justice Feenan and said not every drug case establishes the nexus. Did I hear you correctly?
Right, yes.
Well, then I'm left with, here, what's the nexus? Because you've got, possession with intent, and then you've got a gun in a locked safe,
right.
Correct?
Right.
And if it's not the mere fact that it's drugs as opposed to computer fraud or downloading pornography, I'm really not seeing where the nexus is.
Well, I think the federal precedents are helpful because our statute is not as stringent. So the federal factors at least would be helpful guidance to this. And the state, under the state statute, there may be other factors that would not necessarily be applicable
In other
to
words,
the federal
if it's
statute.
in furtherance of, it certainly is.
Certainly.
During
right.
the commission of.
Right, because it's a lesser standard that we have. In addition to the aspects of the gun being loaded and illegally possessed, look at the type of the gun. Is it an antique that could be kept by a collector, or is it a hunting rifle, something that may have a different use? Here we have a handgun, a .40 caliber Smith & Wesson. That would certainly go to the Commonwealth's argument that is used in relation to the drugs.
Do we know whether or not this residence was in a so-called high crime area?
There was evidence that it was in a high crime area.
Doesn't that suggest somebody was this gun licensed?
It was unlicensed.
It was unlicensed. Okay.
I have a question, but I'd like you to address, please, the second paragraph. Sentence imposed under the section for second or subsequent offense shall not be reduced nor suspended. Okay, that applies to the second offense. Then it says, nor shall any person convicted under this section be eligible for probation, parole, furlough, et cetera. So since a suspended sentence, which is referred to in the first clause, always goes with probation. I mean, there's really no point in having a suspended sentence without probation, and we always have them together. The second clause, it seems to me, applies only to second offenses as well, even though that doesn't parse correctly. I know that the second clause says under this section, which means both paragraphs, but I'm asking you to address it. How can you make it make sense unless the second clause also applies only to the second offender?
Right. And at this point, we're transitioning to the Commonwealth. There's a Commonwealth cross-appeal having to do with
but it's
with
before
the
us.
sentence imposed. Yeah. This is very similar to what the problem addressed by the appeals court in the Birdie decision.
The what decision?
With the Birdie,
yeah.
B-E-R-T-E, which had to do with the armed home invasion statute, which was passed as part of the same legislative package as this. That's Section 18C, this is Section 18B, and they use essentially the same language. That argument was forwarded by the defendants in Birdie, And they argued it would make no sense to say subsequent or second offender if it implicitly did not refer to first offenders, the argument being that first offenders could get probation or suspended sentence. The court in Birdie said, well, if we look at the statutory scheme as a whole, that does not make sense because under Chapter 127, Section 133, it specifically states that you can't suspend prison sentences, and that we presume that the legislature is aware of that statute, and it would not, by silent implication, counter that statute. So what we have in this situation is the defendant, although he's a first-time offender, under the reason of the Birdie case in Section 18C, he still would not be eligible for a suspended sentence or probation. Now, the issue of probation is also dealt with specifically in the statute, and it says, after that comma, just referenced, that no person under this section, if it had intended to refer only to the first portion of that sentence, it would say, or any other person of said, offense, or something like that.
No, I agree with you.
Right.
The way it's written, it doesn't make any sense at all. But I'm saying, how logically can it make sense? You're saying because we can't have suspended sentences, period.
Right. We can't also have probation. And also, probation is doubly, deprived in this section, not only from that sentence, but the last sentence, which says provisions of Section 87, Chapter 276 do not apply. That would, in an otherwise silent statute, that could presumably apply to permit probation. But here is specifically forbidden to this section. So there's two references to probation being unavailable. And there's also, notation that even though first offenders are not specifically precluded from having a suspended sentence, that other section would preclude it.
So here the judge, if I remember correctly, placed the defendant on probation.
Correct.
But didn't give him a suspended sentence.
Right, for 5 years probation on and after the first sentence. Her theorizing was that it made no sense for first-time offenders to be able to have a suspended sentence, which we contend is an incorrect reading of the law under Birdie, and not... Because
you can't have a suspended sentence anyway, given 127, 133.
Right. And her reasoning is if you can't have you should be able to have, if you have a suspended sentence, you should also be able to do probation, even though the statute twice says that's unavailable. And so in our cross-appeal, we're arguing that it was an illegal sentence, and we're asking that to be remanded in a resentencing where the judge can order a 5-year sentence on and after the primary offense. Unless there are further questions.
Just one more question. I take it that my example of drugs being sold out of one apartment, the defendant having another apartment where he keeps a gun in a safe, that constructive possession, although it may exist in that example, wouldn't be having the weapon under his control. Is that correct?
I don't think...
If he's arrested with the drugs in the place where he is distributing them and doesn't have a gun in that apartment, then the weapon wouldn't be under his control.
Unless, correct, I don't think it would be it would not be possessed during the commission of the crime, unless there were some other factors which would indicate that he did possess that weapon.
All right. So he may be, at the same time he's committing this distribution crime, he may constructively possess a weapon in some other venue, but he wouldn't have it under his control, and that's what the statute...
Right, unless there was some other evidence, like he uses that venue to go back and forth to package his drugs or something like that.
But it's alternative, or on possession or under his control. So it's alternative, but he wouldn't have it in his possession. Well, if he's in Boston and he commits a crime and the gun's in Lowell, is it in his possession?
It's in his constructive possession. Whether it is constructively possessed during the commission of the crime, you have to look at the other factors. If it was antique or a hunting rifle or something else, or if there's no other relation, there's evidence he never visits that address or he never visits it in connection with his drug selling operation.
But that's not this case.
That's not this case, right? I think that will be a future case.
Correct.
But I do believe there is a minimal nexus that has to be established between the gun and the illegal activity.
Thank you, Mr. Townsend.
Thank you very much.